February 20, 2026, Washington. The curtain was not merely lifted, it was torn into pieces. If you like political drama, it was Super Bowl level. The United States Supreme Court dropped a bombshell. In a majority ruling, it declared that the sweeping tariffs imposed by Donald Trump in 2025 and 2026 were unlawful. However, it did not say Trump committed a crime, and the POTUS was not a criminal yet. It just said Trump's excessive tariffs were beyond presidential authority and violated the Constitution. Markets jolted. Trade lawyers scrambled. Foreign ministries refreshed their news feeds every minute, afraid of losing any hints in various threads. And before the celebration champagne could even pop, Trump stepped up to the White House microphone and said, essentially, "Fine, I will do it again." And he is doing more than allowed. On the very same day, he signed a new executive order imposing a 10% tariff on imports from all countries and regions, effective February 24, 2026. The next day, he posted that 10% was not enough. Make it 15%. The Supreme Court says his previous tariffs were unconstitutional. His reaction is not an apology, not a refund, not a policy rethink. He doubles down instead. Welcome to the most expensive constitutional fight in modern trade history. Trump is more charming than Bad Bunny. He himself is a bad bunny. Today, we are going to unpack three big questions. First, what exactly did the Supreme Court rule, and why did it not actually stop Trump? Second, what happens to the tariffs already collected that are now declared illegal? Third, what does this mean for the world, for global trade, for China, for Europe, and for ordinary people who never signed up to be part of a geopolitical chess match? Let's start with the core legal issue, because that is where the story gets interesting. The Supreme Court did not rule that tariffs are a bad policy. It did not rule that tariffs are economically harmful. It ruled on something much more technical and much more explosive. Who has the power to tax? Under the United States Constitution, the power to levy taxes and duties belongs to Congress. That is black-letter law. The President executes the law. Congress writes it. Over the decades, Congress has passed laws that delegate limited tariff powers to the President under certain conditions. Three of the most important ones are the Trade Expansion Act of 1962, especially Section 232, which allows tariffs on national security grounds, the Trade Act of 1974, especially Section 301, which allows retaliation against unfair trade practices, and the International Emergency Economic Powers Act, known as IEEPA, which allows the President to regulate economic transactions during a declared national emergency. Trump leaned heavily on IEEPA. He argued that massive trade deficits and certain foreign trade practices constituted a national emergency. Under that emergency authority, he imposed sweeping tariffs not just on one country, but on almost everyone, with rates on China at one point climbing to triple digits. The Supreme Court looked at that and said, hold on. Emergency powers are meant for emergencies. They are not meant to create a permanent, broad-based tariff regime affecting nearly all trade partners for an extended period of time. That goes beyond what Congress authorized. So the ruling was narrow but powerful. It did not eliminate presidential tariff authority. It did not strike down Section 232. It did not touch Section 301. It focused specifically on the way IEEPA had been used to justify a long-term, comprehensive tariff system. In other words, the court cut off one legal pathway. It did not bulldoze the entire tariff house. That is why Trump could pivot so quickly. Within hours, his team made it clear they would rely more heavily on Section 301 of the Trade Act of 1974. The United States Trade Representative announced investigations into a wide range of major trading partners. If those investigations conclude that foreign practices are unreasonable or discriminatory, the President can impose retaliatory tariffs. It is not theoretical. Section 301 has a history. In the 1980s, the United States used it aggressively against Japan. At that time, Japan's electronics and automobile industries were dominating American markets. Washington accused Tokyo of unfair trade practices, imposed punitive tariffs, and eventually pressured Japan into the Plaza Accord in 1985, which led to a sharp appreciation of the yen. The aftermath in Japan included asset bubbles and decades of stagnation, often referred to as the lost decades. Now, is history repeating itself? Not exactly. But the toolkit looks familiar. When the Supreme Court ruled against Trump's IEEPA-based tariffs, some investors briefly celebrated. But seasoned trade officials in Ottawa, Brussels, Tokyo, and Beijing did not pop champagne. They know this is not a reset of American trade policy. It is a legal adjustment within the same strategic direction. The bigger shock, though, may not be the future tariffs. It may be the money already collected. Estimates vary, but between $115 billion and $175 billion were raised under the now invalidated tariff regime. That is not pocket change. That is comparable to the annual defense budget of a major power. Here is the uncomfortable question. If those tariffs were unlawful, should the money be returned? And if so, to whom? The Supreme Court ruling, remarkably, did not answer that. It struck down the legal basis, but did not provide a clear directive on retroactive refunds. It effectively left the issue to lower courts, particularly the United States Court of International Trade. Legal scholars say this was intentional. The justices likely wanted to avoid triggering immediate fiscal chaos. Forcing the Treasury to refund potentially over $100 billion overnight could destabilize federal budgeting, bond markets, and public finances. But that judicial restraint created a different kind of chaos. More than 1,000 companies have reportedly filed, or are preparing to file lawsuits seeking refunds. Major retailers, manufacturers, and foreign exporters with American subsidiaries, all lining up with invoices and customs records saying, "We paid this, and the court says it was illegal." Large corporations have lawyers. They have documentation. They can quantify exactly how much they paid in duties. But what about ordinary consumers? Research from institutions like the Federal Reserve Bank of New York in past tariff episodes found that the majority of tariff costs were borne not by foreign exporters but by American importers and consumers. Prices went up. Margins shrank. Supply chains adjusted. We said this in a previous video. Viewers can search and watch it by following the link in the description. Listen carefully: when you buy a microwave, a pair of shoes, or a laptop, the tariff component is embedded in the final price. You do not see it itemized. You cannot prove how much of your purchase price was attributable to tariffs. So even if corporations eventually win refunds, there is no mechanism to reimburse millions of households who indirectly paid higher prices. That creates a moral and political paradox. Big companies may recover billions through litigation. Consumers, who ultimately financed much of the tariff revenue, get nothing. Added to that is another complication. Much of the tariff revenue has already been spent. Trump had promised ambitious spending plans, including expanded military funding and farmer subsidies. Even if not all promises were fully realized, tariff income was integrated into fiscal planning. If courts order refunds, where does the money come from? Does Congress appropriate new funds? Does the deficit expand? Does the government issue more debt? The Treasury Secretary reportedly hinted that ordinary Americans should not expect to see refunds. Simply put, the money that is gone forever. That is why some legal analysts predict that refund litigation could drag on for years. Trump himself reportedly suggested a timeline of 2 to 5 years. By then, administrations may have changed, and the POTUS himself may have been gone for good. Economic conditions may have shifted. Some claimants may no longer exist as businesses. It becomes, as one justice warned, messy. Now let's zoom out. What does this mean globally? First, it underscores a structural reality about American trade power. Even when constrained by the courts, the executive branch retains significant flexibility through statutes such as Section 301 and Section 232. Congress delegated those powers decades ago. The Supreme Court did not take them away. Second, it highlights a deeper shift in American political consensus. Trade used to be bipartisan in favor of liberalization. From the era of the General Agreement on Tariffs and Trade to the founding of the World Trade Organization, the United States championed rule-based multilateral trade. That consensus has eroded. Under both Trump and Biden, tariffs on China remained largely in place. Industrial policy expanded. Strategic competition language intensified. The Supreme Court ruling may slow certain tactics. It does not reverse the broader trend toward economic nationalism. Third, it injects even more uncertainty into global supply chains. Imagine you are a multinational manufacturer. You source components from Asia, assemble in Mexico, and sell in the United States and Europe. You have to plan capital investments 5 to 10 years out. Now consider this environment. One legal theory for tariffs gets struck down. Another is immediately activated. Rates shift from 10% to 15% in 24 hours. Investigations under Section 301 loom over most major economies. How do you price contracts? How do you choose factory locations? How do you hedge currency risk? Uncertainty itself becomes a cost. European officials have responded cautiously. The European Union has tools, including anti-coercion instruments and countermeasures. But coordinating 27 member states is not the same as issuing a presidential tweet. Decision-making speed differs dramatically. Donald Trump is the world's most authoritarian leader, surpassing his best friend, Xi Jinping. He makes decisions in 1 minute by tweeting an order online. Canada has voiced both concern and realism. A court ruling does not equate to a policy reset. Our new PM in Ottawa seems smarter than the previous history teacher. Japan remembers the 1980s. South Korea watches closely. Southeast Asian economies that benefited from earlier rounds of supply chain relocation may now face new scrutiny under Section 301 investigations. And how about China? China is not Japan in 1985. It has a vastly larger domestic market, deeper integration into global supply chains, nuclear deterrence, and growing technological capacity. But it also relies heavily on exports and advanced foreign technologies in certain sectors. If the United States uses Section 301 broadly against most major trading partners, including China, the world could see a fragmentation of trade blocs accelerate. We may be moving from globalization to selective globalization, where trade flows increasingly align with political alliances. Now let's bring it back to the human level. What does a 15% universal tariff mean for everyday Americans? It likely means higher prices on imported goods. Even if some domestic producers benefit from reduced competition, many industries depend on imported inputs. Tariffs on inputs raise production costs. Those costs often pass through to consumers. Inflation dynamics become complicated. If tariffs raise prices but dampen demand, central banks face conflicting signals. Monetary policy may have to balance inflation control with growth support. For workers, effects vary by sector. Some manufacturing jobs may see temporary protection. Others, particularly in export-oriented industries facing foreign retaliation, may suffer. Globally, developing economies that depend on exporting to the United States could face slower growth. Reduced access to the American market can strain public finances and employment. And then there is the institutional question. What does it mean when the Supreme Court draws a constitutional line, and the executive branch immediately pivots around it? In one sense, this is the system working. The court checked one form of executive overreach. The president used alternative legal authorities that remain on the books. In another sense, it reveals the limits of judicial power in shaping economic policy when broad statutory delegations exist. If Congress is uncomfortable with sweeping tariffs, it could reclaim authority and tighten statutory language. But Congress itself is divided and trade politics are sensitive in many districts. So we are left with a peculiar situation. The court says you cannot build a permanent tariff empire under emergency powers. The president says, fine, I will build it under trade retaliation powers. Companies sue for refunds, but years of litigation lie ahead. God bless you, and hope you can get the refunds before you go bankrupt. Consumers absorb costs with little prospect of compensation. All of this unfolds against a backdrop of strategic rivalry between the United States and China, tensions in the Taiwan Strait, technological competition in semiconductors and artificial intelligence, and broader questions about the future of the global economic order. Trump wants to cure the Chinese cold, and everyone gets a flu shot. If we step back, February 20, 2026, may be remembered not as the day tariffs ended, but as the day the legal battle over executive trade power entered a new phase. The hammer of the Supreme Court fell. But the echo will last a long time. The irony is sharp. The actor who triggered the chaos may, by the time the final refund cases conclude, be out of the office, perhaps watching from a golf course in Florida. The businesses navigating lawsuits and the consumers paying higher prices will still be dealing with the consequences. That is the nature of large-scale policy experiments in a hyperconnected world. Trump declared a national emergency to reshape trade. The highest court told him that he overstepped. The orange guy adjusts and continues under different statutes. But every move echoes through factories in Guangdong, car plants in Bavaria, farms in Iowa, ports in Vancouver, and households everywhere. So where does this go next? Watch three things. First, if lower courts handle refund claims and order substantial repayments, the fiscal implications could be significant. Second, whether Congress steps in to clarify or limit presidential tariff authority, that would be a true structural shift. Third, how trading partners respond, coordinated retaliation, negotiated settlements, or quiet accommodation, will shape the next chapter. One thing is certain. Global trade just became even more political. And politics, as we have learned, rarely moves in straight lines. The Supreme Court tried to enforce a constitutional boundary. The president tested the flexibility of the system. Businesses and consumers are caught in between. That is the story of tariffs in 2026. Not just a legal dispute. Not just a trade war. But a live experiment in how far executive power can stretch, how resilient institutions are, and how much uncertainty the global economy can absorb before something gives. 7 years ago, a comedian in Ukraine was made the president, and the country was ruined with the help of the West. In 2025, a US comedian was elected POTUS again, and the whole world trembled. That is the ironic part: when a crazy guy stays on top of the world, the planet gets crazier.